Sham contracting is contracting which is apparently a subcontract, but in reality an employee relationship. Employee relationships have, under our legal system, a lot of protections built in for the protection of the employee. And the concern is that by entering into a sham contract, the employer avoids providing those entitlements to his employees. Accordingly, a number of regulatory authorities, together with the unions, are very determined to stamp out the practice for a variety of aspects. One is the entitlements of the employee. Two is that it's often associated with poor workplace practices anyway and leads on to poor OH&S and other practices. And importantly, because it deprives the revenue of the tax that would be otherwise deducted from the employee. Further, it can also involve a failure to take out proper workers' comp insurance or to pay properly payroll tax. All those issues drive the regulatory authorities to want to stamp it out. Additionally, they say it's unfair for employers who do the right thing and pay the right amounts to their employees to have to compete with jobs with people who aren't doing that, who are trying to cut corners and save costs. In order to avoid the criticism of being engaged in sham contracting, employers must take precautions to make sure that what they're really doing is subcontracting rather than simply putting another name on an employment relationship. One recent case involved a employer who provided interpreters for clients. Each interpreter was running his own part of the business and was independent of other interpreters and relatively free from the control of his employer. He was able to refuse the work or to accept it, and he was able to set the hours that he was going to work or not work, because they often had other part-time work. The court still found that to be an employee relationship. Particularly important in that, I think, was the fact that the employer did all the invoicing and then, having collected the money from the clients, paid the interpreter. But the employer was put to a great deal of pain and suffering because his relationship with perhaps over 2,000 employees had to be readjusted going back some years. If he'd planned better going forward, or if he'd realised his responsibilities at the time and paid them progressively, he would have been in a much better position. There are a number of important practical precautions that should be taken. Firstly, one shouldn't subcontract to individual persons. One should insist on a corporate subcontractor, possibly with a trust behind him. That shows a degree of formality about setting up the relationship and shows that people had a different intention than employment alone. Next, that subcontract relationship should insist on proper insurance and proper precautions in respect of OH&S and environmental concerns. That is, it should be a real subcontract. Additionally, the subcontractor should be free to delegate the work to others and have those perform that work, or alternatively to work for other employers. They're two key characteristics of a subcontractor as opposed to an employee. It's important to cover those points if you're really going to distinguish yourself from simple employment.